issues are the same for different ventures. So our goal today really is to give you a high overview of some of those legal issues that occur sooner in the life cycle of an entrepreneur and a new venture. So we're going to talk about founding team. So if it's just one person right now, that's great. You're your founding team, but maybe you're going to be looking for co-founders. And then we're going to move on to entity selection. Should you be an LLC or a corporation or a nonprofit? We're going to then talk about some employment related issues, intellectual property, and then we're going to go on to terms of service and privacy policies, because those issues come up a lot for our clients who have online platforms. And finally, the last part will be about how to get our services. And so tonight, as Katie mentioned, we're going to break it up so we're not going through this whole thing and waiting for questions at the end. After a couple topics, we'll stop. We'll ask any questions you have a discussion hopefully with you, because we'd love to hear more about what you're working on. And then, as you will see in the presentation, we have some videos embedded that our students made. So you can actually see some of our students in action, giving some legal education, which is kind of fun. So first of all, the slide says that legal follows business. And that means you shouldn't get too caught up in what we're saying today. It's important information, good to have it in mind. There are some missteps you can make early on that can be hard to undo. So that's why we're going to go over it. But really, when it's time to get legal services is when you're right about ready to go to market with your business. So that's the time that you should probably be consulting a lawyer and maybe applying for services at the clinic. We take a little while to get to people, so maybe a month or two in advance would be great. But generally, the idea is the legal analysis shouldn't really turn what you're doing. Instead, the business is going to lead which direction you should go and when you should pivot. So the first topic we're talking about is that founding team idea. Who should own your business with you, if anyone else? So some of those things to think about is, do you have intellectual property needs? Is there some important invention that needs to be part of your business? And if so, do you own that or does someone else? Does your team have a diversity of skills? Do you have somebody who knows the business side and someone who knows like the technical side? That can be a really strong partnership to think about. Does your team members' skill set really align with the longer term needs of your business? So one misstep we sometimes see entrepreneurs make is they'll need a logo, or they'll need help with one small aspect of what they're working on, and they'll bring somebody on as an owner in their business, when really that's not a person that would be helpful to have long term on your team. So good to think through if you're bringing someone on, whether they really are a good fit for the long haul. So maybe could instead you hire out the worker? Do you have the money to pay someone to design the logo, for example? And finally, you have to think early on, am I going to need a lot of money to start this venture? And if so, do I need to look for investment from friends and family or outside investors? Because they will end up owning a part of your business as well. So when we talk about ownership from a legal perspective, what we're talking about is this term equity. So equity is the legal term for who has an ownership interest in your venture. You can get equity if you provide services to a business. So if I'm going to act as CEO for a venture, I may get stock in return for that. Or you can get ownership or equity for money or assets that you put into a business. Keep in mind that when you give somebody part ownership in your business, you're giving them a say in the governance. Like they're helping make decisions and they're going to be involved. So that's an important aspect to keep in mind. And another one to keep in mind is that equity can be a great way to incentivize your co-founders to work hard with you on a business. So what we know is early on, there's no startup that ever said, I have too much money. Like I have too much money to hire out what I need. Instead, oftentimes equity is the most valuable thing that a venture has at the beginning. So if you structure it correctly, you can maybe use that ownership, granting ownership or giving equity to people in return for their services to really get your business moving forward. So best practices, you want to make sure that if you do have a co-founder, that you're having really frank, upfront conversations around how much you can commit to the business. If you're looking to bring on a new person, you want to make sure you understand, Can you have money for this venture? How much time do you have to devote to the venture? Because sometimes everyone's really well-meaning, but you really don't have the time. So figuring that out up front is great. So wait to give equity or ownership until you have that team solidified. You don't want to do it too early. But you do want to start talking about how much everyone's going to own early on. Just make it clear that you're still just having a discussion and it's not in stone yet. If you have somebody who's been with you, even if it's before you make an entity, who's been involved in helping other than like through UpStart and other resources like UpStart, somebody that though was sort of on your team and then decided to leave, if they had input in creating like your real core mission and other things, you may want to get just a really simple letter from them saying, I no longer have any interest in this venture. I don't claim any assets. That's one tip to keep in mind. So if you did have a co-founder with you, getting an agreement with them that makes it clear they're no longer part of the venture would be really great from a legal perspective. And finally, you may need, depending upon the status of the person that you're co-founding the business with, they may need legal advice around immigration issues, for example. So we are individuals in addition to ventures, and making sure that if there are visa issues or other issues, that those are addressed early. That is one place where you could have a misstep if that's not addressed early on. Okay, so that was our first topic. We're going to move on to entity selection. After we get through this section, we'll stop and then we'll talk about this ownership idea, equity, and entity selection. So the first question is, why even bother forming a legal entity? Sometimes we get, when we are out in the community talking about business law, some people have a negative connotation with the idea of having a business. Like they don't want to form an LLC or corporation because they don't want to have to deal with all that comes with having a business. And what we have to help people understand is if you are engaged in business activities, if you're selling something on the market, those laws are going to apply whether you formed an entity or not, right? So that means sales tax or food safety laws or zoning laws, licensing requirements, all the things that can make having a business somewhat of a headache apply even if you haven't formed an entity. So by forming an entity, what you're doing is creating a liability protection. So if somebody were to sue your business, you're able to say, this much is my business assets and the rest are my personal assets. That's what we mean by liability protection. And that's the main reason why lawyers love entities. That, and we get paid to create them. So it's part of another reason why we like them. But it's a great idea to form a legal entity. Especially, for example, we're going to talk about LLCs. If for some reason you are just one person forming an entity, a single member LLC that we'll talk about is a really simple, straightforward way to get this liability protection. Another reason to form an entity aside from liability protection is because it solidifies your relationships with your co-founders. So if you have a corporation, you're going to issue stock and you're going to know exactly how much every person owns. You'll have a document called bylaws that will tell you how are we going to make decisions. Having all of that written down prevents future arguments or disagreements, and really is your best bet for sure. So when we talk about entities, there are actually quite a few under Wisconsin state law. So they are state specific around the actual provisions within the statutes, but they're similar. An LLC is similar in Wisconsin to one in California, but not identical. So at the clinic, we mostly see LLCs, C-Corps, we occasionally see B-Corps, and we see a lot of nonprofits, occasionally a co-op as well. But those are the four that we're going to talk about now. So this is where I have to do hopefully the tech work. So I'm going to click through to a link here to a video that was done by my student Ryan Lucca that I supervise. So I have to do a new share and pick him. So Jeff, give me a nod if you see Ryan. Okay. All right, so I'm going to play this. If the audio is not good, someone will let me know.
Hi, everyone. I'm Ryan Lucca, and I'm a student associate with the Law and Entrepreneurship Clinic. This presentation will provide a brief introduction to entity choice. I will be discussing 4 entity types: limited liability companies, C corporations, benefit corporations, and non-stock corporations. Then I will review a few of the entity considerations and provide a bit of information regarding creating an entity. Limited liability companies, LLCs, are a great starting point to consider as they provide similar liability protections as the other entities I will be discussing here today, but are considered more flexible with fewer formalities. When looking at entities, a few key characteristics are sources of funding, ownership, governance, and tax treatment. LLC funding typically comes from the founders of the LLC or from revenue from the LLC's operations. While you can obtain some outside investment in an LLC structure, it's generally challenging to obtain significant amounts of outside investment with an LLC. LLC ownership is held by members of the LLC. By default, each member of the LLC has an equal vote, regardless of how much they contribute to the LLC, and all decisions are made by a majority vote of the members. This is considered member-managed LLC, which is the default option as well. When creating an LLC, the founders can instead decide to create a manager-managed LLC. Essentially, being manager-managed allows the members to give some of their management rights to a manager, so the members do not have to vote on every decision. Managers can be members, but they do not have to be. Finally, in terms of tax treatment, an LLC is considered a pass-through entity, meaning that the LLC is not a taxpayer, but rather gains and losses are passed through to the members of the LLC who will pay taxes on their share of the LLC's gains and losses. You should consider using an LLC if there's a smaller group of owners or a single owner located within the same state and a significant amount of outside investment is not necessary. The next entity is the corporation. Corporations are generally considered C corporations or C Corps because their tax consequences are governed by Subchapter C of the tax code unless a separate election is made. Most corporations are C corporations, and these C Corps differ from LLCs in a number of key areas. First, in terms of funding, the structure of C corporations is preferred over LLCs by larger investors such as venture capitalists, so raising substantial capital can be more easily accomplished with a C corporation entity structure than an LLC. Next, governance of a C corporation is similar to a manager-managed LLC in that the owners of the corporation, the shareholders, elect a board of directors to run the company. The board of directors manages the corporation by hiring executive officers such as the CEO or president. It is possible and not uncommon for a person to hold all three roles as a shareholder, director, and officer at the same time in a corporation. Finally, corporations are subject to double taxation, which is the concept that corporations and shareholders might both pay taxes on the same money. This occurs because corporations are considered taxpayers and pay taxes on the income they earn, while shareholders are also taxpayers and pay taxes on the dividend payments from the company. However, double taxation only occurs when the corporation is giving money to its owners. Therefore, if a board of directors decides to reinvest the company's funds into the company rather than making a payment to the owners, double taxation does not occur. You should consider using a C corporation if you want to create a scalable venture and/or one which requires significant outside investment. Benefit corporations, B Corps, are similar to C corporations in terms of funding, ownership, governance, and tax treatment. However, there are additional requirements which need to be met for a company to be considered a B Corp. The first of these additional requirements to be considered for a B Corp is that the benefit corporation must provide a general public benefit, which is considered a measurable, positive impact on society and the environment. Additionally, the board of directors of a B Corp must include a benefits director. And when the board of directors is making decisions, the board must consider its impact on the general public benefit. The B Corp must provide its shareholders with an annual benefit statement, assessing the corporation's efforts at achieving its public benefit. And you should consider using a benefit corporation if you want to commit your company to providing a social good, but would still like to have ownership of the company. There's a significant difference between non-stock corporations and B corporations in that, while both are aimed at furthering a social good, a non-stock corporation does not have owners. Furthermore, because a non-stock corporation does not have owners, it cannot raise money by selling equity in the company. Therefore, funding for the non-stock ventures relies on donations and grants. The non-stock corporation is controlled by the board of directors. The initial directors are appointed by the founders of the company, and there must be at least 3 directors. Future directors will be determined by the board. A non-stock corporation is required to pay taxes similar to C corporations and B corporations unless a tax-exempt status is obtained by becoming a nonprofit organization. Nonprofits are created through a 2-step process and can be used for religious, charitable, scientific, literacy, or educational purposes. Although I will not cover the steps in great detail, to create a nonprofit, you would first form a non-stock corporation, then file a detailed form with the IRS to obtain tax-exempt status. Although non-stock corporations do not necessarily have to be nonprofit organizations, the structure of the non-stock corporation is best suited for a nonprofit organization. You should consider using a nonprofit if you would like to obtain tax-exempt status and can raise the money for your venture through donations and grants. And here's a summary slide to recap some of the entity selection considerations I previously mentioned. The takeaway from this slide is that the source of funding and goals for your entity are important factors to initially consider when deciding which entity to choose, even though they are certainly not the only factors to consider. When deciding to create an entity, it is important to know that states are responsible for regulating the entities within their state. These regulations are provided through statutes and can be different in each state. Although I will discuss the general steps to create an entity in Wisconsin, please note that you should consider consulting with a lawyer and/or accountant for assistance and advice. The general process of creating an entity in Wisconsin involves filing a charter with the Wisconsin Department of Financial Institutions. The charter contains high-level information and details regarding your entity, and there are minimum requirements set by state statute for what must be contained in the charter, such as the entity's name. Another document that an entity will need is the governing document. This document usually will be the result of negotiation between owners to determine and define the business relationship in aspects such as authority of managers, procedures for amending the governing document, and division of profits. Using the LLC as an example, the Articles of Organization, the charter, is where members would make decisions such as whether the LLC would be member or manager managed, while the governing document, the operating agreement, would define in detail the authority of the manager and specifically include which decisions would still require a member vote. A few other entity creation points to note: when creating a benefit corporation, the Articles of Incorporation must include an explicit statement that the corporation is a benefit corporation, must provide for a general public benefit purpose, and must designate an initial benefit director. Also, recall from the non-stock corporation slide that creating a nonprofit organization is a 2-step process which requires creating the non-stock corporation and obtaining tax-exempt status.
Okay,
For listening.
That is the end of that video, and I think I'm so proud of him that he got that much into one. It's almost like a law school course right there, actually. So I'm going to switch back to the presentation itself. Let's see here. Okay, and we're going to go down to here. So I was asked to give a little bit more information about LLCs in particular. So do you see the LLC governance slide? Is that up now for everyone? Thank you for nodding. I appreciate it. So as Ryan mentioned, all of the different types of entities are created by making a filing with the state. So you'll have this slide deck, which actually has the link if you wanted to do an LLC, for example. And you do that by doing a pretty straightforward filing that creates your articles of organization and paying $130. We have actually, when Ryan spoke about member managed and manager managed, he Misspoke a little bit in terms of the voting capacity on the member side, but by default, when you create an LLC, if it's member managed, you vote based on how much you own in the business versus instead of one person, one vote. But other than that, it was perfectly on point. Our preference at the clinic is to have manager managed LLCs. That gives the LLC more flexibility going forward. So if you bring on an investor, your sister wants to invest in your business, but you don't want her to have any management rights, if she's not a manager, then she will only have limited rights as a member if you have a manager managed LLC. And then from a tax perspective, as I mentioned, if you have an LLC that only has one owner, or in Wisconsin, if you have spouses that are married to each other and they're the only two owners, it's treated as a sole proprietorship for tax purposes, so you don't have to do a separate tax return for it. If you have more than one owner, then it's going to be a partnership for tax purposes, and you will be filing a LLC level tax return. Okay, so that is I'm going to stop sharing so I can see your faces better, but that is all on the team stuff and the entity stuff. And now Jeff and I are more than happy to address any questions you have or any comments that you have. We'd love to hear.
There is a question in chat, and it's a Tammy question, not a Jeff question.
Okay, well.
Can an organization start as a non-stock and change to a C-Corp or B-Corp?
It's a really good question. That is the hardest type of transformation to do. So if you've done anything within your Nonstock Corporation, like if you've created the Nonstock Corporation and you haven't applied for tax exempt status, then we're fine. If you have applied for tax exempt status and you've been active, you've gotten donations and grant money and other things, then you're really going to have to, if you start a new business, they're going to have to pay the nonprofit for anything that it receives from the nonprofit. So if you have, if the nonprofit has 501c3 status, if you've applied for it, then any assets in that business are part of this public good. And you can't move them to a for-profit entity without causing problems. I see one about buying, and actually insurance is a great point to make here. So this is a really good point. You definitely could, and we would encourage you all to talk to insurance agents about having business insurance. I wouldn't personally say that I would say best practices would be to do both. You form an entity and you get business insurance or talk about the business insurance. Generally, the entity is cheaper than the business insurance. And so sometimes you have the conversation on insurance and it's not something that you can handle now from a cost perspective or vice versa. But the entities, it'll be $130 for an LLC or a corporation if you file online. If you're a nonprofit and you're creating a non-stock, I think it's $30 to get your entity protection. So insurance is a great point and one that should have probably been in these slides. It's always good to talk to someone about that, but I don't think it doesn't replace the need for an entity from my perspective. Can you share how a company that is an LLC with a nonprofit arm? Yes, so we would consider, so this question is, can you share how a company that is an LLC and also has a nonprofit arm can operate together? This hybrid type idea comes up a lot for us at the clinic, where people come in and they have a for-profit business and they realize they want to reach an audience that isn't able to pay for the services or other things. So they have a nonprofit section. It is very possible to do this, but there are kind of a lot of tripwires for that. You have to be very careful. So basically, any value that's within the nonprofit can't be transferred to the for-profit. So if let's say the nonprofit is developing a curriculum or other things on the nonprofit side, you're out teaching kids and your teachers are learning things and you create a curriculum around it. But then you also have a for-profit and you want to sell the curriculum outside of the for-profit. You can't do a transfer of those assets to the for-profit. That causes a problem without paying fair market value. Like the for-profit would have to pay for it. So another problem people run into is if you have the websites linked together, right? Because then if someone Googles your nonprofit, they're going to find your for-profit. which is not good from the IRS's perspective. You'll want to make sure that you have on the nonprofit side, as Ryan mentioned, you need at least 3 people on your board. You'll want to make sure that that board is independent and is able to make sure that any interactions with your for-profit are done at arm's length and conform with there's a conflict of interest policy required for nonprofits. That means that people don't get transfers that enrich them in a way that the IRS isn't okay with. So you want to make sure you have an independent board. So there are ways to do it. I do think that is a structure that means that it would be great to talk to either the clinic or a lawyer about, just so that you really are aware of how important it is to keep things separate and get the documents you need to do so. Okay. Jeff, are you keeping up with these questions?
I am. So if I normally file, say, a 1040 EZ, I could keep doing so this tax season like before. I think this is adding on to the filing an LLC or insurance question. I suspect this is sort of an add-on to that question.
I got it.
So if she goes and gets her LLC, can she still keep filing the 1040? Probably not EZ once you add Schedule C to it, but I suspect you're going to have a Schedule C if you have business expenses anyway, regardless of whether you're a sole proprietor or an LLC.
That's right. So if you are running a business and making business income, you, as opposed to if you work at a store and they pay you, they're going to withhold the taxes, right? And so when you get your paycheck, it's always smaller than what you think it's going to be because the taxes have been withheld. If you are, you get going in your venture and you're, let's say, instead of working for the store, you're selling things yourself. Like you make quilts and you're selling the quilts out to so now you have the income coming in from the quilts. It doesn't matter if you have an LLC or not. Now you have what's called self-employment income. And you can offset that with like the expenses, like the fabric costs and the other things to make the quilts. But at the end of the day, you'll have to include some profit or maybe loss as a result of your venture. And that would be on a Schedule C of a regular 1040. I don't think that the 1040 EZ would accommodate self-employment income very well, but I am not an accountant and haven't looked at that form for quite a while. So I don't know for sure whether if you can have self-employment income, then it doesn't matter that you have the LLC if it's owned by one person. So the entity doesn't change the tax filing obligation. If your LLC is owned by one person, there's not an additional tax return for that entity.
That's all of our written questions. Do we have any final questions before we move on to our next section? Good questions, really good.
I wanted to add one thing really quickly, which is something that we learned from Sujata. She's not here tonight, but she mentioned if you're a student, and in Wisconsin, you can get the fees for the LLC filing, which I think Tammy said was $130, which is no small fee. You can get that waived if you are currently enrolled as a student in the state of Wisconsin. So consider that for those of you who are still in school or might be anticipating having school while you're starting a business.
That's a really good point. I want to put a pretty heavy caveat on that, though.
Oh, please.
You can only file it in paper, which means you either have to mail it or you have to physically drop it off at the Department of Financial Institutions. Also, that form requires a notary signature. The normal articles of organization do not require notary signature, but for whatever reason, the student waiver requires a notary signature. So going and finding a notary can sometimes be a challenge. Although I will note that for anybody that's in this room, I am a notary. So if you need a notary, let me know, and I am happy to stamp your things and provide notary services.
Great. Anything else? Otherwise, we're going to move on to employment issues. Looks like UPS has it too. So, okay, so back to the presentation. This one. Okay, so this section is actually largely going to be done by video by our founder of our clinic, Ann Smith, and her student, Wilson. So generally, we've talked about the founding team. Those are the people that own the business. But what happens as you move forward in your business and you need to hire employees? So there are legal considerations that come with that. One of the first ones that comes up for people is whether they're hiring independent contractors or whether they're hiring an employee. Oftentimes at the clinic, we have clients come in and say, I'm going to hire this person as an independent contractor. And what we have to help them understand is you don't get to pick in some ways. Instead, there's a series of factors that determine whether someone is an employee or an independent contractor. So maybe it would change the way you interact with that person so that the factors would say they're an independent contractor. Anne's video also goes on to talk about whether if you do have employees, whether they're considered exempt or non-exempt for purposes of overtime and other things. I think given our time limits today, I'm not going to play that section of the video, but it will be on the PowerPoint. So if you do want to go back and refer to it, you'll have access to that video. Oh, it's making me log back onto Duo for some reason. So I'm going to stop share for a second and figure that out. So Jeff, you take over here for a second. I'm going to figure out why it wants me to log back into Duo.
I think this is the part where I do like hand tricks and.
I think that's right.
I don't know. I don't have any magic tricks that I know how to do.
Maybe you could notarize something for us.
So interestingly, there are now remote online notary services, which I have recently learned about that are kind of weird, actually. I mean, notaries are weird to begin with. So a notary is just somebody that watches you sign something and confirms that you're a human being that actually signed the thing. As a lawyer, I don't really understand why they exist because they're not witnesses. Like they're not people who are saying, I saw that person sign the thing. They're just saying the person that signed this thing is the person who signed this thing. They're kind of weird.
That's kind of weird. Well, thanks for the aside on the notaries.
There you go. Aside on notaries.
We're going to play the employee section. So.
Hi, my name is Ann Smith, and I'm with the Law and Entrepreneurship Clinic.
Coming through okay?
With me today is Wilson Fay. We together are going to talk to you about human resources legal challenges that face startups. But before we move into the legal issues, I want to talk to you a little bit about something that I think is really important for you to be thinking about as you're thinking about human resources issues, and that is corporate culture.
Tammy, can you turn the volume up at all?
Right now, it may be just you, and whatever you do represents what you believe in. But as you start adding people, you have to start thinking about what kind of culture is it that you want to create. I'm going to share with you a couple quotes from employees that work for big companies and the kinds of things they said about the companies that they're working for. Someone from ADP said, "There's a great work-life balance and recognition that life happens both inside and outside of work. Diversity is embraced and appreciated, and there is a spirit of charity and acceptance." Then a quote from someone that works at Microsoft: "There is consistent effort to be transparent and have a diverse work culture. People are encouraged to speak up and solve problems." Now, when I think of a company I want to work for or do business with, and I hear the kinds of words that are in these statements made by employees, I'm encouraged and want to work with them. And I would want to work in an environment that spoke that way. So think about culture as you think about all these issues. With that, I'm going to turn it over to Wilson.
Hi, as Ann just mentioned, my name is Wilson Fay, and I'm a student associate at the Law and Entrepreneurship Clinic. One human resource legal issue that most startups will face is worker classification. Further, how you classify your workers and the type of workers that you employ at your company will have an impact on your corporate culture. Today, Ann and I will discuss the two main categories of worker classification. First, I will discuss employee versus independent contractor classification, and then Ann will address exempt versus non-exempt employees. So what is the difference between an employee and an independent contractor? Well, the answer to that question is often easier said than done in practice. But generally, an employee or a W-2 worker is a person who is hired to work for a business for compensation and is subject to the employer's direction as to the details to how to perform his or her job. Whereas an independent contractor or a 1099 worker is a worker who contracts business or another person to provide services in exchange for compensation. Unlike employees, independent contractors are not protected by most federal, state, or local labor laws that provide a social safety net or are intended to protect workers. Further, independent contractors are responsible for paying their income, Social Security, and Medicare taxes. There are several benefits to hiring workers as both independent contractors and as employees. Starting with employees, employees are generally the type of worker you want to hire if you want a close corporate culture that relies on its personnel. Employees are generally more engaged and immersed in your company and its corporate culture as they will be consistent, long-term members of your company. Additionally, employees will generally owe your company a duty of loyalty, preventing them from working for your competitors while you employ them. Further, companies are allowed to exercise more control over the quality, detail, and nature of employees' work compared to independent contractors. Now, moving to the benefits of independent contractors are generally highly skilled workers in their particular craft or field. Additionally, independent contractors are a short-term commitment for your company and do not require a large initial investment, unlike employees. Independent contractors also require minimal supervision and company resources as they often provide their own tools. Further, independent contractors are generally less expensive than employees, as companies do not have to pay unemployment or workers' compensation taxes for independent contractors. And further, your company will likely have less liability for the actions of an independent contractor compared to employees. Although you may want to classify your workers one way or another, you may not have a say in the matter, as there are several state and federal agencies that impose various tests and rules for worker classification, and they levy strict penalties for improper classification. These penalties can include back pay and overtime compensation, covering employee benefits, including stock options, retirement benefits, and health plan coverage, along with disability payments and workers' compensation, liability for tax and insurance obligations, including unemployment and workers' compensation taxes, liquidated damages, and even civil monetary penalties. So the question I'm sure you're all asking is what you need to know to avoid these penalties. Well, as I hinted at the beginning of this presentation, the laws surrounding employee versus independent contractor classification are hazy and have been going through immense change. Therefore, it will be much more beneficial to direct you to resources that can help you ensure that you properly classify your workers. However, as a general matter, it is important to know that there are several different tests used at the federal and state level, and all these tests are fact-intensive and examine multiple factors. However, these tests generally state that independent contractors retain control over the method and manner of their work, perform work that is outside the normal course of your business activities. They specialize in a particular service and are paid for that service or task, and are only hired for the time required to complete that task or service. Additionally, they offer their services to the general public and not just your company, retaining economic independence, often working for several businesses at once. Further, independent contractors provide their own tools to complete the task or service. Now we'll discuss the three major federal agencies along with the Wisconsin agencies that invest worker misclassification and discuss resources to avoid misclassification in your company. As I'm sure most of you know, the IRS is the nation's tax collection service, and it investigates worker misclassification because employers must withhold certain taxes for employees, but not for independent contractors. The IRS states that there is no set number of factors, nor will one factor determine a worker's classification. However, the IRS does look at three categories of factors when determining a worker's classification. First, factors that show that the employer has behavioral control over the worker. Next, factors that show that the employer has financial control over the worker. And factors that indicate the type of relationship, such how the parties view the relationship. Luckily, the IRS provides helpful tools to help you determine how your workers should be classified, such as the SS-8 form, which is a request for the IRS to determine the classification of your workers for you. And next, they also offer the voluntary classification settlement program if you've determined that your workers have been misclassified, and they'll provide partial relief against the misclassification penalties. Both of these resources and more are available on the IRS website, and I've put a link at this bottom of this slide to access them. The next federal agency that sets worker misclassification requirements is the Department of Labor. The Department of Labor sets minimum wage and overtime compensation requirements under the Fair Labor Standards Act. The Department of Labor is currently in the process of changing its test it uses to classify workers. On March 8th, the final rule will go into effect, which employs a 5-factor economic reality test. The 5 factors of the final rule are the nature and degree of the individual's control over the work, the opportunity for profit or loss, the skill required for the work, the permanence of the working relationship, and whether the work is part of an integrated unit of production. The Department of Labor provides resources and information on its current test and the final rule on its website, which is linked below. The last of the three major federal agencies is the National Labor Relations Board, which enforces laws that protect employees' right to collective bargaining and to form unions. Companies generally run into less worker classification issues with the National Labor Relations Board compared to the IRS and the Department of Labor. But misclassification under the National Labor Relations Act can trigger misclassification in other agencies. When determining a worker's classification, the NLRB applies the 10 non-exhaustive factors listed on this slide. In addition to the federal level, there are several state agencies in Wisconsin that set worker classification requirements. In Wisconsin, there are four more main categories of laws that establish classification requirements for employees versus independent contractors, which are unemployment insurance laws, worker compensation laws, labor standard laws, and civil rights. Fortunately for us in Wisconsin, the Wisconsin Department of Workforce Development provides interactive tools to help determine how your workers are classified. And they look at the specific facts of your workers to avoid misclassification. These tools are provided on their website, which I've linked on this slide. I hope the information I provided on employee versus independent contractor classification will help your company with its HR legal issues. I will now turn it over to Anne to discuss it.
Okay, so we are gonna leave it there. So now is the time to ask any questions you might have on employees. I will say it is a big surprise because you might think I'm hiring a full-time employee is way down the line. For an example, I worked with a nonprofit at the clinic who had teachers that were working on average an hour and a half a week, or sorry, even a month in that case. And because the nonprofit was telling them when to come and giving them the books to use to teach with, the $30 they were paying those teachers a month, that was an employee. And they had been misclassifying them for about 15 years. So you really do have to think about these things much sooner than you think in terms of this, whether that someone is an employee or not. And it doesn't have to do necessarily with how much time they're working for your venture. So any questions at all?
So Tammy, I have a question for you, and I think this comes up a lot. When people aren't sure, would you recommend that they call the Department of Workforce Development, to ask these questions, like sort of the hypothetical? Because that's where, as they're deciding what the job looks like, I think a lot of people are afraid to reach out. So what is kind of your advice there?
Yeah, first of all, I think I will say that DWD has been pretty good when we call to ask questions. We do so on behalf of our clients and we don't use names when we do so. So they do allow for you to do that on a sort of an anonymous basis. Their online tool that Wilson was referencing has gotten better as well, like where you can answer some questions. The way to kind of think about the classic independent contractor is, let's say they're a web designer. And you hire them to make your website, but they work with 10 different people, and you tell them you're going to give them $200 to make the website, and that's how much they're getting. You're not paying them by the hour necessarily, and so they may make money on that, they may not. That's what a classic independent contractor looks like, versus somebody that you say, I need you here at this time. You're going to be in my store and use my resources. That means that they're more likely to be an employee. And we have found the state has I guess it's now been 2 summers ago, but they convened a special subcommittee at the governor level to try and address all the misclassification out there, because so many people say people are independent contractors, and then that means they're not getting unemployment insurance and other things. So there has been a big push in the state of Wisconsin to try and dig in for this classification. So it's good to start out right if you can. Great. Well then, Jeff, you can take over and move on to IP.
Perfect. Did you just, you shared the presentation and then the videos were able to be part of that?
Yeah, so the IP video is linked in the presentation, but you'll need to do a new share after you click the link so that it'll show that window when you're after you.
I wanted to say there's a question in the chat, not from
Oh,
me.
I can
great.
select multiple windows.
Yeah, can a board member and or owner be an employee? That's a super great question. So if you are an owner of like an LLC or a corporation and you're working for the business, you are generating. Well, let's stick with LLCs. You're getting what's called self-employment income, like we talked about. You are not an employee for purposes of these tests as an owner. If you are however, like an officer in a corporation, then you likely would be considered an employee for tax purposes, but and for others. So anyway, it is very fact specific, but generally if you have an ownership interest and you're at the beginning and you're like in an LLC, that's helpful. But on the board side of things, like, so from Department of, and Jeff, you can chime in too, like DWD has different standards than the IRS has. I'm a tax lawyer, so I always go back to tax law, and I think that's the most important thing. But on DWD will say you have to get workers' comp possibly if you have 3, I don't know if they call them employees, but they count board members who aren't even paid in that. So on DWD side, you really do have to be careful about who counts and who doesn't count. So I would encourage you to either call DWD or look at their website to get, specific information on that.
Yeah, it can be really confusing. I have to admit, like every time I get this question, I always have to look it up because it's just, it's not intuitive. As you say, it sometimes includes directors, sometimes it doesn't, and how many people it is and where you get it. It can be confusing.
Yeah.
Okay, well, let's jump into the presentation and we'll see where we go when we get to the video. But we should work here. Let me make sure we start in the right place. We are going to talk about intellectual property protections first. It looks like we have questions after intellectual property, and then we'll talk about terms of service and privacy policies. If we have time. It looks like we have about a half hour left. I'm pretty sure we'll get through all of this, but let's see how it goes. All right. All right, everybody can see it should say intellectual property types of protection. Yes. Excellent. All right, so we're going to have a video here from one of our students, and they are going to talk to us today about patents, copyrights, trademarks, and trade secrets. I'm assuming you cannot see this video.
Yeah, you have to go back up to like the screen share and say share new, and then when you click, do you see where that is, Jeff?
New share. Aha.
Share. Yeah.
New share. Here we go. Let's share this one. All right, now you should see this and that. Are we good?
Audio up a bit if available.
By my email provided on this first slide.
Better?
Intellectual property law governs some of the most valuable assets that businesses today possess. In short, there are 4 main categories of intellectual property law. That is patents, which protect inventions or processes, copyrights, which protects creative works and software, trademarks, which protect brands, and trade secrets, which protect valuable information that is not publicly known. Each area of IP law offers a different set of protections for the underlying idea and has a different set of requirements needed to receive those protections. Patents protect inventions, which includes machines, products of manufacture, compositions of matter, and processes or methods of producing some result. The patent holder has the right to exclude others from making, using, selling, or offering to sell their invention for 20 years. Patent protection is only available once a patent has been registered with the United States Patent and Trademark Office. A patent may be obtained for an invention if it is useful, new, and non-obvious. The Patent Office reviews prior publications, products, and patents to determine if an invention is new and different from previous inventions in a way that would not be obvious to change. This includes disclosures made by the inventor themselves. In the US, an inventor has 1 year to file for a patent after making a public disclosure of their invention, but typically cannot receive a patent in any other country after any public disclosure. Inventors should be mindful of making public disclosures or sales of their invention and should only make confidential disclosures of their inventions. Patent rights are limited to the areas in which the patent was obtained. So if a patent holder only holds a US patent, they cannot stop someone in another country from making or using their invention unless they apply for a patent in that country as well. The rights provided by a patent also only allow the patent holder to stop others from making their invention. They do not give the patent holder the right to make their invention. Obtaining a patent on an invention does not necessarily mean that a patent holder can make the invention without also infringing someone else's patent. Between fees and legal costs, obtaining a patent can cost on the scale of tens of thousands of dollars, and enforcing patent rights in court can cost on the scale of hundreds of thousands to millions of dollars. Inventors should be mindful of when considering filing for a patent. Copyrights protect original creative works, such as books, music, pictures, films, and software. Copyright law gives the author the exclusive rights to reproduce, adapt, publish, perform, or display their work, but does not give the author the right to exclude from independently creating a work similar to theirs. Copyright protection lasts for the duration of the author's life plus an additional 70 years. Or for an anonymous work or work for hire, the protections last for 95 years from the work's first publication or 120 years from the year of its creation. Copyright protections exist at the time the creative work is first fixed in a tangible medium, but in order to enforce those rights, the work must be registered with the Copyright Office. So if a creative work is valuable, register it as soon as possible. Trademarks protect brands and give the exclusive right to designate goods or services as originating from the brand and to use the trademark with those goods or services. Trademark protections can apply to any word, name, symbol, device, color, product configuration, or noise used with a good or service to identify the source of the good or service. Trademarks may be protectable without being registered, but registering a trademark with the USPTO gives notice to the public that they're registering claims ownership of the mark, gives a legal presumption that the trademark is protectable nationwide, and gives the exclusive right to use that mark on or in connection with the services or goods listed in the registration. Trademarks fall into one of four categories: fanciful or arbitrary, where the trademark is made up or totally unrelated to the product or service, such as Exxon or Dove soap. Suggestive, where the trademark has some connection to the product, but it requires a leap of imagination to make that connection, such as Netflix. Descriptive, where the trademark describes the product or service, such as American Airlines. Or generic, where the trademark is only a generic statement of what the product or service is, such as a shoe manufacturer named Shoes. Fanciful, arbitrary, and suggestive trademarks are outright protectable. The public must actually associate a descriptive trademark with its product in order for a descriptive trademark to be protectable, and generic trademarks are not protectable. Moving on to trade secrets. Information that gains value by not being publicly known can be protected as a trade secret. This includes things like formulas, marketing plans, customer lists, or manufacturing processes. Trade secret protection only applies to misappropriation of a trade secret and does not protect against independent development or reverse engineering. Additionally, in order to receive protection as a trade secret, efforts must be made to maintain secrecy of that information. Such efforts may be limiting who in a business may access the information, non-disclosure agreements with any vendors who need to know it, passwords, safes, and any other precautions that are reasonable under the circumstances. Trade secrets have the advantage of indefinite protection that lasts as long as the information is secret. The costs of reasonable efforts to maintain secrecy are minimal compared to obtaining and enforcing patent rights. Trade secrets are also particularly useful for processes or inventions that would be difficult to reverse engineer or to detect patent infringement within.
Oops, let's see here. Let's go back. All right, we are, what's that? We're good?
You're there.
Okay, good, excellent. All right, so we've learned a little bit now about patents, copyrights, trademarks, and trade secrets. I do want to stop here briefly, and if anybody is doing anything that relates to food, we often get a lot of questions about the protection of recipes. Protection of recipes is not subject to copyright law, so you cannot protect recipes with copyright law. The only protection available for recipes is through trade secret. So let's talk about some best practices. We want to understand who owns the IP and legally assign it to the company where needed. We have to put contracts in place that assign IP created by employees to the company. So the really important thing to take away from here is that when you're creating intellectual property as part of the company, in the normal course, the company will own the intellectual property. This is not always true. Patents, for example, are owned by the individual, not by the company. Any assignment of intellectual property rights has to be in writing. So if you develop a patentable thing, even while working for a company, there needs to be a piece of paper, there needs to be a contract, a written contract between the employee and the company, assigning the rights in that patent to the company. For any inventions prior to the existence of the company, in the normal course, you are also going to assign the rights to that intellectual property to the company. That intellectual property may have value, which could be an asset that is contributed to the company by the inventor or by the holder of that intellectual property. Tammy always tells me there are a lot of caveats to that. So I will tell you, there are a lot of caveats to that. But in the normal course, you are going to want to assign any intellectual property that you created prior to the company in writing, often along at the same time that you sign that operating agreement, or that you sign any bylaws, or well, you wouldn't sign bylaws, but that you would sign any documents providing employment to a C-Corp. For trademarks, before adopting a trademark, this is really important, before adopting the trademark, search thoroughly to make sure nobody else is already using it. One of the things that happens most frequently is people start using trademarks and they get really attached to those trademarks. And then their product or service becomes really popular. And then they find out that there's somebody that's already using it, and they aren't able to use this trademark that they've already put a lot of effort into. So before you start using your trademarks, my recommendation is always to come up with 2, 3, or even 4 names that you really like. And that way, if you do a search and you find the one that's sort of at the top of your list and that isn't available, or other people are using something even similar and you just want to sort of stay away from their names, then you already have a list of things that you already like, and you don't have to worry about this problem years down the road when your product is actually popular and you need to then scramble to find a new trademark. This can be really important, particularly in consumer packaged goods and things that you sell to people. Keep thorough records, again, relating to patents. Keep thorough and careful records regarding inventorship. Inventorship is not a thing. Who the inventor is not something you get to decide. Something who has contributed to the conception of the invention is an inventor, whether you put them on the patent or not. And you must disclose all inventors on the patent or risk invalidating the patent. So it is critically important that you know who the inventors are. And it's not in general something you get to decide. You can't say, oh, that person's not part of the company, so they're not going to be an inventor. If they contributed to the conception of the invention, they are an inventor, and you need to get an assignment from them if they are not going to be moving forward with the patentable device. Public disclosures are important timestamps in American patent law. As was mentioned in the video, public disclosure can be a bar to foreign rights entirely. But in the United States, you have 1 year from that public disclosure. Public disclosure means telling anybody the details of the invention, not just sort of the generalities of the invention, but something that would enable that person to sort of know what the device is and how it functions. Not just that I invented this device and it generally does A, B, and C, but you do need to disclose in some amount of detail. But those disclosures from the first date of disclosure, even if it's to your mom or your sister, if they are not under a duty of confidentiality, those can count as public disclosures. For example, presentations to class or presentations in front of a group like this would most certainly count as a public disclosure. You need to protect trade secrets. There are two ways to protect trade secrets. As was mentioned in the video, trade secret is really good protection for things that you don't want to disclose to people, right? Part of the patenting process requires you to disclose your invention to the public. So if you don't want to disclose it, or there are good reasons not to disclose it, or it's just simply not something that's subject to patent law, not telling people is a really strong protection. But you need to protect the trade secret. There are two ways to protect trade secrets. The first is with a contract called a non-disclosure agreement or a confidentiality agreement. These are relatively standard documents. As a lawyer, I don't often say that. There are not a whole lot of documents that I call standard documents. Non-disclosure and confidentialities are relatively standard documents. So anybody that you are going to disclose your invention to should be under a non-disclosure. The other way to protect your trade secrets is to not actually tell anyone. And this means people even inside of your own company, right? If you are making software, for example, and the front end people don't need to know how the back end processes work, don't let them have access. Put them behind passwords that the front end people don't have access to, right? That way they can't learn what the trade secret is, right? Even if they're not under a duty of confidentiality, if they don't know the trade secret, they can't disclose it. Finally, register any potentially valuable copyrights. Registration of copyrights is $45. It is very, very cheap. It is a relatively straightforward process. So if you are creating songs or books, or I saw in the chat that there was a question about educational materials. We'll talk a little bit about educational materials when we get to the questions and answers. If you have things that are really important to you, filing a $45 copyright can be a great way to get really strong protection in those works. So let's talk about questions. Let's see if we can pull up chat here. I saw chat around here somewhere.
Yeah, I can go ahead and do some if you want, Jeff.
Yeah, let's go through some questions. Have you been following along here, Tammy?
I have been, yeah. So what concerns should service providers worry about when using someone else's curriculum?
Yeah, this is a really good question. Curriculum can be really hard because unfortunately copyright attaches in the creative expression of an idea. It does not attach to the underlying idea itself, right? So if I'm teaching somebody, let's say intellectual property law, the underlying idea of intellectual property law is not protectable. My specific creative expression, the video I created that explains to you about intellectual property law, that's protectable by copyright. You can't take my video, but if you create a new video that even contains much of the same content, as long as you're not copying my script exactly, maybe word for word, then that is possibly not infringing somebody's copyright. So curriculum can be really hard because we have to separate out the things that are not protectable from the things that are. So understanding what exactly you're contributing to the underlying idea can be really challenging. Best practice, throw a copyright notice on it regardless, right? You can always let the courts figure that out, right? You can always figure that out later, right? So if you just put the circle C, right? There's a circle C, and we're going to differentiate that from the circle R that we use for trademarks. But the circle C, the year that you created it, and your name or your company's name. That lets other people know that that work is subject to copyright, regardless of how thin that copyright might be. It would be really good practice to simply put copyright, the year, and your name or the company name to indicate to others that it's covered by copyright.
Okay, and that question in particular was looking at using someone else's curriculum. So oftentimes, there'll be limitations if it's a printed material about how many copies you can make and distribute it out that way. Jeff, this is your area of expertise, but other ideas if you have a workbook or something that someone else created and then you're using it in your business.
Yeah, if you're using a workbook, particularly, well, I mean, any workbook, if you're using workbooks or forms or other people's curriculum, it's really important to understand what the rights are in that workbook. If it's a mass-produced workbook, there are usually, when you go to the website for that workbook, or even inside the cover of the workbook somewhere, there will be instructions on how to license and how to use the work. Typically for educational purposes, you can often make copies that are for classroom instruction only, as part of a fair use defense for classroom instruction. You cannot go crazy with that. So you cannot photocopy an entire book, for example. But if you just wanted to photocopy 1 or 2 pages from a book, the sort of default rule is up to a chapter, depending on sort of the length of the book. You're probably fine for in-class purposes. But try to make sure you understand the rights that are associated with that curriculum before you start using it.
Okay, we have another curriculum question, which is another good one. When you're developing a curriculum using independent contractors, can the product be copyrighted to the company, or does it need to have all the names of the people who created it? I love this question because this is what my students would ask me this question, and I would tell them to go talk to Jeff. So this is perfect.
Yeah, this is you have 2 options here. And we talk about these options sort of in the alternative. You can actually do both of these things, and I would recommend that you do. My recommendation is going to start with making sure you have a written contract with your independent contractor who is developing this curriculum for you or with you, right? You want to make sure that you both understand from day one who owns what and who has rights in what. So that contract should, in addition to all of the other things that it's going to set out, how much people are being paid, that they're an independent contractor, that they have, right? All of the things we talked about with employment stuff, right? We're going to have an intellectual property section that outlines what the intellectual property rights are. And when people are creating written works like curriculum, one option that's available to us is a work made for hire. And work made for hire means I am hiring you to do this thing for me, for my company. Therefore, anything that you create automatically belongs to me, right? It never belongs to the other person to begin with, right? The person that you're hiring, the independent contractor, it never belongs to them. And we call that a work made for hire. The next paragraph is going to say, just in case the courts wouldn't consider this a work made for hire, because work made for hire doctrine can be really finicky sometimes, we're going to have a second clause. And that second clause says, if for some reason it's not a work made for hire, you agree to assign to me all of the rights, right? Or to my company, right? You're going to assign to me all of the rights. Right. And that means that person is giving you ownership of the things that they have created. So those are sort of the 2 main ways of making sure that you maintain ownership of the curriculum. If the other person isn't interested in transferring ownership, if they want to retain some rights, then you're talking about what we call a license. And you can have implied license, you can have unwritten license, but I do not recommend it. Absolutely put in writing the terms and scope of the license. If they're going to expect a royalty, if they're going to expect some sort of payment, if they're going to limit how or where you can use it, you can only use this in your classroom for this specific course. You can only use it in the state of Wisconsin. You can only use it for online education. There might be some limitations that go along with it. Make sure all of those things are in writing.
Great. Okay, and then someone linked to this story on Madison.com, which I love, about the chocolate maker who was an attorney who beat Mars when they like sent a cease and desist on her trademark. And that brings us to the trademark question, which is, can the name of my company be trademarked?
Depends on the name of your company. If the name of your company is your own name, then it might take a while, but possibly. This is where we get into A, is anybody else using that name already, or using a name that is the phrase that we use is likely to be confused, right? If a customer, if a consumer of your goods were to see that other name, would they think that the two entities are related? Would they think that the two are the same person, right? If you're creating, if you are an airline, and you decide you're going to sell airline services as Delta Airlines, right? Well, there's already a company called Delta Airlines, so you cannot name your company Delta Airlines, right? Can you name it Alpha, Beta, or Gamma? Maybe, right? If there's not already an Alpha, Beta, Gamma airline. Right. On the other hand, if you manufacture faucets and there's an airline company called Delta Airlines and you call your faucets Delta Faucets, well, nobody who is buying airline services would reasonably think that the airline also makes faucets, right? So you can call your name, you can call yourself Delta Faucets, right? So this is a very tricky question that involves looking at what are all of the other names out there that are being used, and what goods and services are those names attached to, and are they similar to your goods and services, right? So obviously Nike exists for shoes and footwear and clothing, right? But if you were to make instead luggage under the name Nike, right? Is that like clothing? I don't know, maybe, maybe not. I will say here that one of the things that is especially true in intellectual property is you're only as right as you can afford to be. So if Nike sends you that cease and desist, well, regardless of whether you're right or not, if you can't afford to fight Nike, you don't get to use it, right?
Yeah, and trademarks are one of the major things we do with clients. So if you are interested in looking at trademark work, you certainly are welcome to apply. But Jeff, so trademarks are expensive, relatively speaking. And so Jeff is right about, for sure, about doing the search early and looking at your names because you're going to get attached. And that's important to do even if you aren't ready to file for federal trademark protection, because what is it? The minimum would be over $300 per class.
Minimum's right, or they just raised the prices on them. They used to be 225, but now I think they're close to 260, 270 for the lowest priced options.
For the lowest, and it takes a long time. So if
it does take a very long time.
It takes a very long time. So if you start though selling your goods and service, and Jeff's going to tell me, I've listened to him say this enough, so you correct me if I'm wrong. You start getting trademark protection from the day that you start using that name and selling your goods and services, even if you don't register it. So even if you don't go forward with registration, the thing we want to help you try and avoid is having to rebrand down the line if you get a cease and desist letter, or you decide, okay, I'm ready to file for protection for this trademark. And then you find out then it's not available. So that's why all those, searching ahead of time is really useful.
That's right.
Okay. So at what point would adapted curriculum that you bought from someone else become something that could be trademarked, and how much does it have to be changed?
So we're gonna say copyrighted instead of trademark, because copyright applies to creative works. So this gets to how much things have to change when you're basing your thing on prior works. And this is a really, really tricky area. And by and large, it has to change a lot. By and large, it has to change a lot. Basically, my best advice is understand what the underlying idea is and write it from scratch. Do not sit there and look at one thing and then look at the one thing and then try to create something else, because courts have found that doing that is almost like directly copying. So I would not sit there and have the one document up and then try to create another document here. Try to understand what the underlying message is, what the underlying idea is, because that's not protectable. and then create your own thing. And even if it adopts a similar format, even if it adopts a similar style, that may be okay. But it'll at least be created independently of the other thing, right? Independent creation is really important in copyright. The one doctrine we want to be really cautious about is called derivative works. And copyright law protects from derivative work. So it protects somebody from coming along and taking your thing and selling it as their own. So we want to be really careful when we're basing works on other people's works and make sure that we're really just taking the ideas. I know that's not a very good answer, but
I see one more question in the chat from Rosa that I think everybody would probably benefit from. I also just want to give 5-minute warning till the end of class, so we have time to wrap it up too.
We are not going to get to terms of service and privacy policies, but that's okay. That's okay.
Yeah, so that question from Rosa is, it seems like there are a lot of contracts needed for many different situations. How would you advise a new business starting out? Should we spend money to have a lawyer on retainer? Are there generic contracts that we could adapt for our business?
I'm a realist here. I have to say, I am a realist here. I get that lawyers are expensive, except for the lawyers at the Law and Entrepreneurship Clinic, where we're free of charge. So applying to the Law and Entrepreneurship Clinic is always a good start. Obviously, that's not always going to be available to you. You know, we're not at your beck and call. So if you need to have something quickly, that can be a challenge. What I would advise, be open, honest, and transparent with the people that you're working with, right? And when you come to an agreement with someone, even if it's not a legal document, even if a lawyer doesn't write it, even if it's not a document that says contract on top, put it on a piece of paper, put your agreement on a piece, at worst, put it in an email and email the other person and say, it was great talking to you today. I understand from our conversation that we agreed to A, B, and C. If you do not agree with this understanding, if this is not how you understood this, please respond and let me know. And that at least puts a timestamp on your conversation and fixes in time, contemporaneous with the agreement, what you both thought the agreement was at the time. That's something everybody can do. If you're going to come to an agreement with somebody and you feel like it should be in writing, right? I've talked about some things here that kind of need to be in writing. It doesn't have to be a writing that was written by a lawyer. Write it down and say, you person are giving me ownership in X in exchange for Y dollars, in exchange for $10 or whatever it is. Then at least you have a piece of paper that says what the agreement was, right? And that's better than not having a piece of paper that says what the agreement is.
Yeah, and I'll also say, like, as far as trying to find documents online, obviously we always hesitate a little bit on that. Just, but again, in the real world, if there is a big company out there doing something that similar to what you want to do, so this comes up with like liability waivers a lot for our clients, right? So if you have a small nonprofit that's going to take kids and go do something, and you look online at a big nonprofit that can hire a lawyer, or a big organization that is doing the same thing and they have a liability waiver, if a student was drafting it for you within our clinic, we would tell them to go out and look for other examples and then draft one off of that using those principles. So if Jeff had gotten to terms of service and privacy policy, he would tell you, you'd want to look at businesses that are larger, that are similar to what you're doing when looking at things to include in your terms of service and privacy policy. So we always caveat around the idea of just taking stuff off the internet. But that said, sometimes that's the best you can do, other than applying to, so it's on the PowerPoint, which you're going to get, but it's uwle.org, and then you click apply for services. And it's important for us to know that you are with this UpStart program. So Jeff, how are they going to tell us that when they apply? Is there a way that they can put that in the application?
There is a referral in the application. The other best way is, because there's a limited number of you and there's a limited number of us, if you email Tammy or I, Just for the sake of a single point of contact, I'll say email Tammy. If you email Tammy and say, hey, I applied for services with the L&E clinic, I put an application in, then we know to look for it and we can flag it early so that we know that it came from you. There is a referral source in that application question. So please put UpStart because we look at that.
Great.